Further to this, in the International Covenant on Civil and Political Rights, Article 5, it says nothing in the present covenant may be interpreted as implying for any state, group, or person any right to engage in any activity or perform any act aimed at the destruction of any of the rights and freedoms recognized in the present covenant, here in or at their limitation to a greater extent than is provided for in the present covenant. You cannot limit an individual's rights and freedoms apart from what the International Covenant allows it to do. All state parties are under obligation to follow international covenants. The international covenants are the controlling mechanism that govern domestic laws. They cannot limit human rights and fundamental freedoms unless it is in accordance with the covenant. There always has to be a provision to measure the rights and freedoms in place that allows you to exercise these inalienable rights. The obligation for them to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. The obligation comes out of the covenant itself. When we look at articles of law, together these articles of law produce the obligation on the executive powers. They must make provisions to give effect to the rights, and they must not take any actions aimed at the destruction or limitation of the rights. Combining these articles of law together and subsequently bringing forth the domestic application. The U.S. Reservations, Declarations, and Understandings concerning the International Covenant on Civil and Political Rights. It is a Senate advising consent understanding which shall apply to the obligations of the United States under the covenant, that the United States understands that this covenant shall be implemented by the federal government to the extent that it exercises legislative and judicial jurisdiction over the matters covered therein, by the state and local governments, to the extent that the state and local governments exercise jurisdiction over such matters. So if it's a state regulation or enactment, then the state has the obligation to respect your rights. If it is a federal enactment, then the federal government has the obligation to respect your rights. Why? Because they have to implement this for the fulfillment of the covenant. The Senate's advising consent is subject to the following declarations: that the United States declares that the provisions of Articles 1 through 27 of the covenant are not self-executing, were not already provided for by existing legislative or other measures, each state party to the present covenant were not already provided for by existing legislative or other measures as may be necessary to give effect to the rights recognized in the present covenant. All of the Constitution bring forth the operations of law that respect the common law rights and fundamental rights and freedoms. The provisions and mechanism of law available for the individual to enforce the rights. They flow out of the international law, the international covenants through the Constitution Act, and subsequently into the justice system, through the judiciary, through the administration of justice. The United States of America is under obligation to take judicial notice of your natural rights and fundamental freedoms and to protect them. They have the ability within their courts to provide a remedy for a violation against your inalienable rights. When you look into the Constitution of Indiana, Section 12, it states, all courts shall be open. Every person by injury done to him in his person, property, or reputation shall have a remedy by due course of law. Justice shall be administered freely and without purchase, completely without denial, speedily without delay. It states the Constitution. Each state constitution, you're going to find a section that deals with it specifically. It's going to state that the courts are open and you can use the court to enforce your rights and to enforce natural law. The court shall be open for every person, a general statement, and when you look at the word person, we understand that the word person can mean a man or woman. It's an indication that we are able to have a remedy for a violation of our rights. The courts are open to us to use to seek remedy against a limitation or denial. of our natural rights. The Constitution, whether federal or state, they acknowledge and respect and guarantee the use of the exercise of natural rights. Looking at Constitution Act of Canada, Article 7, it states that everyone has a right to life, liberty, and security of the person, and that right not to be deprived of thereof except for a principle of justice. Florida Constitution, Section 2, Basic Rights. All natural persons, female and male alike, are equal before the law, and have inalienable rights, among which are the right to enjoy, defend life and liberty, and pursue happiness. When you look at the Constitution of California, Section 1 states all men are natural, free and independent, and have certain inalienable rights, among which are those of enjoying, defending life and liberty, acquiring, possessing, and protecting property, and pursuing and obtaining safety and happiness. The Constitution of Illinois. All men by nature are free and independent, and have certain inherent inalienable rights, among which are life, liberty, and pursuance of happiness, to secure the rights and the protection of property. Governments are institutions among men deriving their just powers from the consent of the government.